This time, we'll call the meeting to order. I need an approval of the September 22nd, 2025 minutes.
I'll make the motion.
I have a motion. Do I have a second?
I second it, but I wasn't here last time, and I think my name's on the list as being present.
We'll make that,
Okay.
we'll make that correct.
Change that.
Strike that from the record.
Okay.
Otherwise, a second is held.
Yes.
All in favor? Aye. Motion passes. All right, Tommy?
Thank you, Mr. Chairman. What we have here tonight is a case of administrative review regarding 8 digital sign permits. I will read the addresses of those permits. 512 West Main Street, 1185 Preston Street, 716 North Church Street, 301 West 7th Street, 915 North Church Street, 5490 Bradford Hicks Drive, 4205 Bradford Hicks Drive, and 5476 Bradford Hicks Drive. All these permits were submitted to our codes enforcement officer. The codes enforcement officer denied these permits, and so the applicant, Roland Media, is seeking administrative review to overturn the decision of the codes enforcement officer. So before we get into our public hearing, I'll ask if the applicant wants to address the Board of Zoning Appeals. And please state your name for the record, please. Press the button. Yes, ma'am.
Okay, all right, thank you. My name's Carly Darby. I'm an attorney, and I'm here on behalf of Roland Digital Media. You stated that, I just wanted to clear a couple things up. So first, I think you mentioned it was an application for 8 permits. I believe it was 9 permits.
Okay, I have 8 here in my hand. I know that we heard 1 last week. So are you saying that you submitted a total of 10 permits that were?
No, it should be a total of 9. That's
Okay,
correct.
so we heard 1 last month, so
Okay,
this
great.
will be 8.
Yes.
Okay.
So, as you mentioned, Roland sent the application. This was sent on or about July 24th of this year. In response to his application for the 9 sign permits, Roland received a letter from Mr. Walter Rutherford erroneously categorizing Roland's Watchfire digital display. That's the type of digital billboard. That's the company that makes the digital display. Erroneously categorized it as a flashing sign pursuant to section 11202.22 of the municipal zoning ordinances of the city of Livingston. Not only that, but the letter fails to deny Roland's application and fails to mention his application at all. So again, we're here because no permits were given and denial of those permits is ambiguous at best. Regarding Roland's proposed signs constituting flashing signs, I will reiterate that the same is erroneous. Roland's digital signs comply with both TDOT and the Federal Highway Administration requirements. Each stationary ad runs for 8 seconds before changing to the next stationary ad. The zoning ordinance defines flashing sign, as you all are well aware, as a directly or indirectly illuminated sign on which artificial light is not maintained stationary and constant in intensity and color at all times in use. Roland's proposed signs clearly don't fall within the city's definition of a flashing sign because the signs displayed will be maintained in a stationary position and will remain constant in intensity and color at all times while in use. So, I mean, this is not the first time this has come up. This isn't the first time this issue's been before this board, but this issue's come up in other places as well. And when interpreting similar prohibitions on flashing signs, courts have concluded that such provisions to not prohibit digital signs like the ones proposed by Roland because such signs merely periodically change static images rather than flash. And I think that case was provided for you all with the letter. That is the Village of Clemens case. Moreover, the Federal Highway Administration has made it clear that signs that change messages using digital technology do not violate a prohibition against intermittent or flashing or moving signs, moving lights. And you can refer to the memorandum dated September 25th, 2007. Essentially, Roland's proposed signs do not run afoul to the city's purported prohibition on flashing signs. The board should also reverse Mr. Rutherford's potential denial of Roland's application on the grounds that his proposed signs would violate the prohibition on flashing signs because it's a clear deviation from the city's prior interpretation of its own zoning ordinance. In his application for this appeal, Roland has provided several examples of the city allowing other sign applicants to use digital technology. To deny Roland the same opportunity that the city has afforded to others clearly violates Mr. Roland's equal protection rights under both the U.S. and Tennessee constitutions. I think Mr. Lemon, who was before this board last month, was a little more diplomatic than I am, and I'm just going to call this what it is. It's home cooking an outsider, and it's clear. And so my question is, when is that going to stop? On the way here, I practice up here in Livingston, so I frequently observe these legal signs. I observe signs with graphics literally flipping, and those clearly meet the definition of a flashing sign per the city's ordinance. Another reason this potential denial is problematic is that the zoning ordinance exempts government signs from regulation. So Section 11203.9.3, Section C, provides no limitation, restrictions, or requirements herein are applicable to government signs. As such, the city could lawfully post signs identical in all respects to the signs requested by Roland. There's a Sixth Circuit Court of Appeals case that gives the example of the government could say, hey, everyone, go get your vaccines. But that would prohibit someone like Roland advertising for the local pharmacy to say, get your vaccine here. Indeed, based on the digital sign being used by the Livingston Chamber of Commerce, it appears the city makes good use of this exception, and of course you all are familiar with that sign, and the same has been provided to you. Meanwhile, if Roland or any other person or entity wanted to post a physically identical sign, they would need to comply with the zoning ordinance. A broad exemption for government signs such as this has been viewed by courts to be content-based and unable to survive the very high bar of strict scrutiny, and referring back to the letter with the application that is cited by several cases. As this board has already heard, the city impermissibly regulates signs based on their content. That the city relies on content to determine whether or not a sign is allowed cannot be disputed based on Mr. Rutherford's handling of Roland's original application for the sign at 106 West 7th Street. In his response, the email which you all have been provided, he literally says, what will be advertised on the proposed sign? He might as well have said, what content are you putting on your sign? That's exactly what he asked. The United States Supreme Court's decision in Reed versus Town and Gilbert made it clear that government regulation of speech is content-based if a law applies to a particular speech because of the topic discussed or the idea or message expressed. The city's reliance on content as a factor to determine whether or not to permit a sign cannot be permitted. Finally, the Livingston zoning ordinance also fails to include any time limits on the processing of sign permit applications. Licensing schemes, like the city's zoning ordinance, that subject the exercise of First Amendment freedoms to the prior restraint of a license must contain certain procedural safeguards in order to avoid constituting an invalid prior restraint. And that is from the opinion in Feed Children Incorporated versus Metro Government of Nashville and Davidson County. The city's handling of Roland's second batch of permit applications demonstrates the need for time limits. So again, we're here, he applied a month ago, he hasn't received an actual denial. That letter in response, let's just call it what it is, it was the runaround. It doesn't even mention this application, it doesn't say in response to your application, it just says, we think watch fire signs constitute flashing signs. So it's confusing, it's ambiguous, and the zoning ordinance's lack of a time period within which the city must grant or deny a sign permit, when coupled with the other constitutional issues that I've outlined, render the ordinance unconstitutional. And so, for these reasons, we're asking that the board determine that Roland's applications should be granted. And then I will allow you guys to ask any questions.
Any questions from the board for Ms. Darby? Thank you, Ms. Darby.
Thank you.
Mr. Griffin?
Good evening, everyone. Again, we're here today on an administrative review, and the role of the board on administrative review is to determine whether the building official's decision is supported by a proper reading of the zoning code as you all interpret it. What happened here was Mr. Rowland submitted 8 sign permit applications. A 9th was considered last meeting. These were for watch fire digital display signs, which were 113 square feet in sign face area on a large metal pole structure, about 20 feet high, and the dimensions are included in a depiction in the permit application. Mr. Rutherford evaluated these watch fire digital display applications based on their size, their location, and considered whether there would be a flashing sign. It's been clarified both at this meeting and the last meeting and through Mr. Rowland himself that these signs would change image at least every 8 seconds. So we have a ordinance that describes what a flashing sign is, and we have an ordinance that says flashing signs are illegal in all zoning districts. We have a definition here. There was no definition in the case for the town of Clemens in North Carolina, but here we have a definition to apply. And a flashing sign is a directly or indirectly illuminated sign on which artificial light is not maintained, stationary and constant in intensity and color at all times in use. It doesn't say at least for 8 seconds. It says at all times in use. And the signs proposed by Mr. Rowland in these applications clearly constitute a flashing sign, which is illegal in the town of Livingston. For that reason alone, the denial of these permits was proper. Also, which Mr. Rutherford mentioned, but which Ms. Darby did not, were the reasons given of this exceeds the maximum number of signs per sign structure and per side of a sign structure. Under 11-203.9.3 subsection J, there are a maximum of 2 signs per sign structure, and only one sign is allowed on each side of a sign structure. So you can essentially just have a front and a back. The front and the back can be different, but if one side changes every 8 seconds, That's more than one sign per side of a sign structure, and it would violate that particular portion of the ordinance as well, and therefore the denial was proper on that basis. Finally, this is a structure-supported ground sign, and we have rules regulating what a ground sign is and how big ground signs can be in each zoning district. All of the sign applications in this case were in commercial districts except for, I believe, the 7th Street application. That was in a residential district. In all districts, so residential and otherwise, other than commercial and industrial, a ground sign can be 6 square feet if it has a regular foundation that attaches it to the ground like a masonry structure. In commercial and industrial districts, you can have a sign area with 24 square feet. These sign faces are 113 square feet, clearly well beyond what the maximum size allowed is for a ground sign. So there were 3 separate and independent bases to deny these sign permits. These bases were conveyed to Mr. Rowland on July 31st. His application is dated July 24th, so the permits were promptly denied. There's nothing ambiguous about this denial. It clearly sets out the reasons that it does not comply with the code and specifically cites the code sections. There was no response to that other than this administrative appeal, and it's clear that Mr. Rowland knew that this was a denial of these sign permits because he filed the administrative appeal. We won't get into the legalities of content neutrality like we did last time, but we've cited numerous cases that explain these signs are content neutral. The United States Supreme Court has confirmed that. The United States Circuit Court for the 6th Circuit has confirmed that government signs are content neutral as well, and the role of this board is not to decide whether something is constitutional or not constitutional. That is for a court to decide. This board's role is to decide whether the building official's denial of these permits was proper based on a reading of this code. It clearly was proper, and we would ask the board to affirm the building official's decision. Any questions?
You got
All right, so thank you, Mr. Craven. At this time, what we'll do is we'll begin our public hearing. We will give each citizen 3 minutes to address the board. If you would like to speak, please raise your hand and be recognized and state your name for the record.
My name is Kelly Coleman. I'm a lifelong resident of Livingston, Overton County. I pay a lot of taxes. I pay a lot of business taxes. I served on the city council for 4 years. It's been a number of years ago. The City of Livingston City Council does not get everything perfectly right 100% of the time. However, it was very clear to me during my 4 years, we had a mission to clean up and to limit additional, you can call them flashing signs, you can call them fire watch signs, I don't care what you call them. We worked hard to limit the proliferation of additional signs in our community. Did we cross every T and dot every I exactly right? I don't know. The City Council has worked hard subsequent to that to even further tighten the city codes related to signs. Now, the attorney, on behalf of Mr. Rowland, stated, we call this home cooking. I call this follow the money. It's all about the money. If I'm in the advertising business, I want a digital sign, a billboard on every corner of this town because that means money for me, right? The intent of this body, the City Council, was to limit additional signs. Now, when I speak about money, I speak as a first-hand individual who has first-hand knowledge. Every time that this city of Livingston, which happens to scrape for every dime that the city gets for our parks, for city streets paving, for work at the airport, you name it, we scrape. Our city has paid thousands and thousands, and I bet you hundreds of thousands of dollars directly or indirectly defending sign ordinances because of advertisers from out of town, such as Mr. Rowland. I'm tired of it. I'm angry. I'm disappointed. I suggest, and I'm coming to the city council meeting, I suggest that they make the rules even tighter and more clear to include specific sign manufacturers such as Firewatch. If that's what we need to do, by dang, that's what has to happen. The city council was clear. The intent is to limit more signs. Signs that we have in town that are flashing, they're grandfathered in. Okay? Yes, they're at the city police department. They're at the chamber. We can't do anything about that.
Thank you, Kelly.
Thank you.
Barbie Roberts. I've spoken at this before, trying to defend our codes, there's been a lot of effort put into codes for this town to make it beautiful, homey, just like we want. We don't want 8 or 9 digital signs all over town. The citizens don't want them. We're asking you to please follow the codes. Let us have a town that we're proud of, whether they're flashing or not. And if something's changing every 8 seconds, the lighting and the color is changing. To me, that's flashing. But it doesn't really matter. We don't want them. We're asking you, the board, to stand by this and not give in to this appeal that we don't want as citizens of this town. Thank you.
My name is Ron Lane, Livingston resident. I'm not smart enough to know about definitions and all those sorts of things, but it seems to me that if our town has a rule that says we're not supposed to do something, I would like to not do that, please. So I'm mirroring what has just been said as just an ordinary citizen, doesn't know very much about what's being written down. The concept of a Las Vegas Strip is not what Livingston is all about. Livingston is more about low-end rural community. This citizen would like to keep it that way. I would urge this group to follow the ordinance and not allow the sign. Thank you.
Watch it. Hey, folks, I just want to give you a little history lesson. Dave Rowland Digital Media. I was asked here twice by local businessmen. 2015, David Sadler asked me to come before the Planning Commission to talk about digital signs. I had no idea, didn't want to put one up. We got plenty of signs between Allgood and Livingston. Soon after that, a local businessman made a request, says, you put a sign up, I'll be the first one to go on it. We went through that gyration. Fast forward 10 years, other local business people, we need a sign. Folks, in spite of what Mr. Coleman said about me, it's not all about the money. We've got signs in 22 counties. Most of them have digital signs. In Cookeville, there are 121 billboards. That's poles. Multiple faces, over 25 digitals, some mine, some of the competition, Lamar out of Louisiana. Cookeville, I know you don't want to hear this, it's going to sting. Putnam County has 10 times the retail sales of Livingston. You say, what do we do about that? What does it have to do with the sign? It has to do with one thing. The people that come from the north, from Dale Hall Lake, down Highway 111, Highway 52, when they come to the intersection, they're on the way to Allgood or Interstate Drive. They pass a Walmart in Allgood, but on the way to that Walmart, they pass a Burger King and a McDonald's. You have a little chance to slow them down with a sign right there. Again, you've got a wonderful downtown, you've got a wonderful park. How are you going to get them over there? Over and over, I've been requested by local small business people to have a sign there to direct folks downtown. Several years ago, around 2003, as I understand it, maybe some of y'all remember it, some won't, I think a request came from Bentonville, Arkansas. They wanted to put a Walmart in Overton County. As I understand it, I may be wrong, but some folks got together and said, we really don't think we need a Walmart in Overton County. I think the response was, we'll never have to worry about that again. Well, guess what? It's an Allgood. Allgood receives about $200,000 a month in their portion of the sales taxes. Folks, we're not talking about signs, we're talking about dollars and cents. The same thinking that's here tonight opposing this is what brought Walmart to Allgood in Putnam County. Thank you very much.
My name is Susie Matty, and I have lived in Livingston approximately 5 years now. Our home is located basically in the center of where all these signs are going. I already have 3 street lights and church lights and blackout curtains so we can sleep at night. I left Cookeville after 5 years because it looks like a downtrodden Las Vegas.
My name is Rita Richardson. I've lived in Livingston for 2.5 years. We moved here from Nashville. We thought about living in Cookeville, but we didn't like the sprawl. We chose this town because it doesn't have flashing signs and billboards everywhere. Please uphold the ordinance. Thanks.
Andre always hates to say this, but I'm a little confused.
Can you say your name for the record?
I thought we were here.
Oh, no. What's your name?
Oh, say my name? You got to talk loud to me, you know that. Arno Proctor. I thought we were here to decide if Walter made a mistake in denying the things. Not about allowing different sign sizes, not about the allocation of where they were, simply to see if Walter made the right decision. Am I correct on that? Okay, thank you.
Any more public comment? Okay. We will close the public hearing and reopen the BZA meeting.
What is in front of us as Board of Zoning Appeals will be the question, did our codes enforcement officer at the time properly interpret the zoning code with regards to these 8 digital sign permits, and in doing so, properly deny these 8 sign permits? That's what's in front of us today.
Some of these street names on here, one of them's questionable, there's one, Preston Street and West 7th Street. Is those commercial areas or residential?
West 7th is residential, the Preston, I think, is C3.
So I take it it's at the bypass.
Probably, I can't say for sure.
Because I know 95% of Preston Street's residential.
I'm going to look for, do I have a motion this time?
That motion that we uphold Walter's decision on the signs.
Okay.
I'll second it.
We'll call it roll.
Call the roll.
So we have a motion by Shirley uphold the decision of the codes enforcement officer with regards to the 8 digital sign permits from Roland Media. We have a second by Tommy Rooker. So a vote of yes or aye is going to uphold the decision, and a vote of no or nay is to not uphold the decision. Any questions regarding the motion on the floor? Tommy Rooker.
Aye.
Shirley Myers.
Aye.
David Langford.
Yes.
Daniel Elder.
Aye.
Mr. Chairman, motion passes. Vote of all ayes.
Thank you, Tommy. Okay, without any further business, do I have a motion to adjourn?
I'll make the motion to adjourn.
All right. I'll make the second.
You'll second?
I was like, All in favor? Aye. We're adjourned.